Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
Hi, well, you posted one last night. I love this, and I will just say, if anybody wants to do this in New York, I am your guy. I love this suit. I initially thought it was kind of ridiculous, and then I really started looking into and thinking about it. So we're going to start in Los Angeles, and Los Angeles County is being sued by a number of people, but presumably, or primarily, I guess we'll say, by because they're John Does, you don't really know exactly, but it's a class action by students who were at the academy, and they were told on, let's call it off-duty hours, that will be the question, to quarantine during COVID in their rooms. So to be clear, according to the complaint, they were not allowed to leave their rooms, thus restricting their activities. And there certainly is a lot of discussion in the Fair Labor Standards Act about whether you have to be paid for off-duty time. We call it waiting time, which is time in between job duties. Let me give you an example here, because this is a good one. So person number one drives to an appointment in city number one, and that appointment is done. And then there's another appointment in city number two, but he's got a couple of hours to do what he wants in between. As long as the employer says, hey, do whatever you want between those two meetings, then no, there's no compensation requirement. So waiting time. But where your activities are restricted in that regard, there would be compensation due. And I didn't see this in the complaint, but I thought I'd look this up. And this is really located, for those who want to read this, in volume 29 of the Code of Federal Regulations, section 785.14, all the way to 0.16. So what those sections say, and I presume where the lawsuit's going, is, listen, by restricting us to our rooms, we were not free to engage in off-time activities, right? You restricted our activities. Yes, we could do whatever we wanted in our rooms, but you told us where we had to be. And there's a lot of on-call discussion and things. If that's true, I think this lawsuit has very much a good chance of winning. And I want the same one. So anyone in New York, feel free. I'll sue on this.
Yeah,
Curt, what do you think?
I think this is the suit that we've been waiting for. Way back when we first started having the quarantine problems, but actually went back to Ebola and, before COVID, there was some concerns about what happens when you tell a firefighter to quarantine. And there's a general principle in the FLSA that the employer is only obligated to pay for work. But there's a little bit there's a big discrepancy, because it sounds simple, right? If the employer requires you to do something for work, then they have to pay you for it. Sounds simple, okay? The problem becomes is, what happens when I tell someone you have to shave? Or what happens when I tell someone you smell, you got to take a shower?
Or check emails off time.
Oh, well, that's a little bit different now. There's a thing called preliminary and post-preliminary activities and so on. Checking your email would be more in the realm of compensable. So it very, very complicated. We spent hours going through this in our FLSA class, okay? Bottom line is, I've been waiting for this case, and it just never came, and I couldn't believe that it hadn't come. Now it comes in the form of fire academy students quarantined at a hotel. And I know you don't practice in this area, and there's a lot of sort of trap doors and mirrors, and very, very difficult to navigate around. There's another section in the and you will certainly, what you just said is exactly what they'll be arguing, that they told us to go to this hotel. When your employer tells you to do something, your employer tells you to go stand in the corner for 8 hours, you got to pay them to go stand in the corner for 8 hours. That makes sense, okay? There's another section, and this is what makes the FLSA so difficult, is there's a section in there, section 29 CFR 553.226 on training time. And Within that 553.226 is exception C. What we call in my class, we call it exception 6, because we teach there's 6 exceptions to the training. You have to pay someone to go to training, and this is one of them. It's called the Fire Academy exception. And so that if you are assigned to an academy and you are required to go there, for example, you're required to go to the State Fire Academy. Many state fire academies have a live-in program. The National Fire Academy, you may be required to go there if you're a fire investigator or whatever, you're required to go there. The exception in 553.226 says that unless you're in class, even though you're required to be there, unless you're in class, the time is not compensable. But
here I think there's a nuance.
Well, there's a lot of nuances, okay, and
right.
there always is, and that's going to become the battleground. So I guess to sum up where I'm at with this, I was really looking for this case to come up, but I wasn't thinking it was going to come up in the context of a fire academy.
Right.
And if there's one area that I think is a definite problem for the plaintiffs, it's going to be the fact that they're at a fire academy.
Yeah, I think the nuance here is that they couldn't leave the room, because when I first read this, I'm like, oh, come on. It's like you send someone to a conference right, where they have their off hours. But if they were truly told you're not allowed to leave your room, that's the factor that I think, right? You have no free time anymore.
It could. The question and the way that it's worded is, are they free to pursue personal pursuits, or are they free to engage in personal pursuits? So are they free to read a book? Are they free to go on the internet? Are they free to watch TV? Are they free to take a nap? Okay, now compare that to maybe a police academy. I know our state police academy is a live-in academy, and at 2 o'clock in the morning, they'll roust them out and they'll go for a 2-mile run. Right. Okay, or they'll get up at 3 o'clock in the morning and do calisthenics.
And they got to be paid for that.
Boot camp. Absolutely, that's my point. That's the kind of control I think that you're looking for to get around this fire academy exception. But when you are pretty much free to do as you choose, now, again, within limits, okay, and this is the same thing on a deployment, which, I was a USAR task force leader, and this is an issue on deployments as well. You're deployed to Hurricane Katrina, you're down in Mississippi, or you're on a wildland fire out in Montana, you can't go home. Okay, and you're told, get in that tent, you're gonna, stay in that tent or stay at the base area, but you're not permitted to go to the movies, or you can't go to the convenience store or whatever. You've got to stay in camp. That's fine. It's not compensable as long as you get to choose, do I take a nap? Do I watch TV? Do I write my girlfriend a letter, or whatever it may be, an email, or whatever it may be? So again, a lot of nuance. I was hoping this case was not going to involve a fire academy. That's my point, because I think you take the fire academy out of this, now it's a different thing. Oddly enough, according to the complaint, they paid the instructors 24 hours, which they would have to do because they're pretty clearly supervising what's going on. They would have to be paid 24 hours, but under the fire academy exception there, I don't know. It's interesting. There's a lot of nuance in this one.
If they said they weren't free to leave the academy, I wouldn't have this belief. But when you confine someone to an 8x12 or whatever room,
right?
That to me is so restrictive on your, it's like the paid on call rules, right? Look, if you have to be at a place in a certain amount of time, like 5 minutes or 30 minutes, where they restrict your area, even though you're free to do whatever you want, they got to pay you for that, at least in New York State, because your travel is restricted because you have to be within a certain amount of area. I think if they said you could be anywhere on the academy, do whatever you want, walk around, no big deal, you're free, no big deal. But you start restricting someone to their room, I don't know. That's strange.
That's a great point. And I'm surprised that they didn't allege a California state law wage and hour violations, because California has a lot of protections for employees that go beyond the FLSA.
What if
And
it's a statutory time limit, maybe?
Yeah, you know, like this, I'll give you an example. The flight attendants are exempt from the FLSA. People involved in aviation are exempt from the FLSA. But, and just so you know how flight attendants are paid from the moment the door closes on the jet until the door opens on the jet. They're not paid to get there at the airport early. They're not paid to board the passengers. They've got to be on the jet like 40 minutes before it takes off, and then 30 minutes people start boarding and all that. They don't get paid for that. In fact, if there's a ground stop and the door is open, they don't get paid. They get paid.
Now I know why they never want to open the door.
Okay, so that's and under federal law they're exempt, so that's fine. Under California law, they have to be paid. Okay, so now there's several class action lawsuits by flight attendants
landed in
who
California,
were flying over California, going into California, leaving California. They're saying, wait a minute, under California state law, you have to pay us from the time we got to the airport. We went to our check-in briefing and did all that stuff. So again, California has a little bit more protection than most states do, and certainly they have more protection than the FLSA does. So interesting case. You know, we'll see how, we'll keep an eye on it. We'll see how it all turns out.